Welcome. Then Nelson versus Wade.
Good morning, Your Honor. Erin Lane appearing for Mr. Wade.
All right. Good morning, Ms. Lane. You're Ms. Cox, I presume?
Yes.
All right. I have Ms. Cox in the courtroom.
Is there video or just?
It's just audio.
Oh, sorry.
Yeah. All right, Ms. Lane. So I'll start with you. Go ahead.
Sure. This is a motion for a change of venue for this case. The whole adversary is based off of a default judgment that was obtained in state court. As soon as my client was made aware of the default judgment, he did go into state court for a motion to vacate that judgment. He was told to bring evidence before that court that he was improperly served. He did so. The court denied his motion to vacate on May 6th of 2022. And then Mr. Wade immediately filed an appeal with Washington State Courts of Appeals, Division Number 2, under case number 569345 on May 11th of 2022. And this matter is currently under review with the Washington State of Appeals, and we believe that this should just be moved there for them to determine whether or not that motion to vacate was properly denied.
All right. So what is the current status of that appeal? Is it just pending at this point?
It's still under review.
I received information that it has not been perfected yet. I think a payment needs to be made by January 9th in order for the court to not sanction Mr. Wade for not paying the court fee, is my understanding, Ms. Lane.
All right. So it may be hanging by a thread, but at least right now it's still active.
Yes, Your Honor.
All right.
Yeah.
So then let me ask the underlying question then. I mean, if the appeal is not successful, is that existing state court judgment going to be dispositive in this adversary proceeding? I mean, is it a preclusion type of thing, or are we still going to have an actual proceeding that we need here? I guess that's to you, Ms. Lane. I mean, is there going to be a defense if the state court judgment stands, or am I just going to be stuck with those findings and it's just preclusion here?
No, so there would be, yes, I believe there would still be a defense, even though there was because this is all brought on a default judgment. So this was never litigated in state court. So Mr. Wade does have defenses against the claim brought against him.
All right. Ms. Cox, you might have a different view on that. Do you think preclusion would apply, assuming the state court judgment is upheld? Is that going to be preclusive here?
We would say yes, Your Honor, because while it was a default judgment, there was egregious discovery and misconduct that led to that default judgment. So we do believe that it would be dispositive here in the underlying bankruptcy. In terms of whether Mr. Wade has any defenses or not, I mean, the answer in the state court, he admits everything. He's just sort of his claim is, well, yeah, I said all these things, these horrible things about Mr. Nelson, but I still believe them to be true. I mean, is that a defense? I think the court is asking, are we going to have another mini trial here? I think. Is that what the court is asking?
Well, I'm trying to figure out, or if at least, I mean, oftentimes when we get to bankruptcy court with state court judgments that have already happened, I mean, the parties don't always agree that it's preclusion, but we usually get summary judgment motions arguing the preclusion issue before we, get to trial, because sometimes they're preclusive and sometimes they're not. I don't really know enough of the underlying to say anything about it today on the merits, but sort of just, I'm trying to figure out how we do this sort of most efficiently from a procedural standpoint. And so if there is a possibility that this will be resolved under a preclusion doctrine, I guess my next question is, and let me just cut to the end, Ms. Lane. I mean, I don't think I can change venue to the state court on a discharge adversary proceeding, but what I'm thinking is, just from economics and economy, should we be staying the adversary proceeding until we know what the state court does? And that way, if the judgment is upheld, then I think the next step here is summary judgment motions on preclusion. And if that doesn't resolve it, then you have the trial here. Or alternatively, if the appeal is successful and then we don't have an underlying judgment, then we can kind of better schedule what we need to do if we're going to actually have the full trial on the merits here. Because I think I already issued a scheduling order in this case, and my scheduling orders run pretty fast. So if we don't stay it, you're all going to be up against doing things here pretty quick before we know what even happens to that state court judgment. So I guess I'm interested in both of your thoughts on whether it makes sense to stay the adversary proceeding until the state court either will make some substantive ruling on the appeal, so we know whether we've got a judgment and potential preclusion, or we have no judgment and we're just completely on a clean slate here. I'll go to you first, Ms. Lane. Do you have thoughts on that?
Yeah, I think it does make sense to actually stay the proceeding and see what happens with the state court.
All right. Ms. Cox, your thoughts on that?
Well, just procedurally and technically speaking, we haven't briefed that before the court today, but candidly, we have that coming this week before Your Honor in a summary judgment that we plan on filing. The issue on preclusion is
coming anyway.
It's coming anyway, and we would just request that the court wait to read the briefing on both sides before it rules on whether a stay should be implemented here. We believe just this narrow motion of a motion to change venue is the reason. And I understand, Your Honor, you're very practical here in your prior rulings. I think you're thinking just.
I'm just trying to help the parties.
Yeah,
I'm not trying to make you do something that people don't want to do. I'm just, trying to keep everything as economical and efficient as we can. I don't intend to do. I'm not trying to impede on people's rights or make them do something they don't want to do. I'm just throwing it out there.
Yeah, I appreciate that, Your Honor. I would just argue that, or request that we can get to the preclusion issue once we've had that authority before the court and it's been fully briefed.
All right, I'm not against that. All right, Ms. Lane.
Sure, can I step in on that one? I would say if we're going to go to claim preclusion, I cannot talk to it, the claim preclusion issues, I think they might actually even change once the state court decides whether or not to uphold the lower court's decision. I think that could change things. And so why put all of this work in time if the state court's decision can ultimately change things?
Well, correct. And that's the trade-off, because here's the way these things generally work here is on any judgment that I get in state court that's on appeal, it's still a final judgment for me for applying preclusion doctrines. The appeal doesn't really matter. I would just rule as if there was no appeal and there's a final judgment, because that's the law. But then what happens is if I ultimately ruled it was preclusion, and then subsequent to that, the appeals court overturns the underlying judgment, then you come back and my judgment gets vacated because it was based on something that was overturned. So it's just kind of like, for me, it doesn't change the analysis. It just sort of changes the order of the work, or perhaps how much work the parties need to do. But like I said, I'm open-minded to do it however the parties think they want to do it. It's a little less efficient, I suppose, to do it all before knowing if the state court judgment's going to stand. But I also don't want to sort of insert myself more than I should if the parties want to proceed in a different manner. And it sounds like maybe doesn't sound to me like you're really on the same page on this particular matter. It sounds like Ms. Lane would prefer to stay it here and Ms. Cox wouldn't. And so I think I will not, particularly because I raised it sua sponte. There's not really a motion to stay the proceeding. Ms. Lane, if they do file for summary judgment or even if they don't and you think it should be stayed, maybe you should bring that motion. I just wanted to raise it, but I'm not going to order it on the parties just when I raise it in the context of a hearing and they haven't talked to their clients or maybe fully thought through exactly what they want to do. So maybe you talk about it outside the courtroom after this hearing, and if you come to an agreement, certainly I will let you know that I'm certainly willing to stay it by agreement if you come to that decision. And if you don't, Ms. Lane, and you still think it makes sense to stay it, then just file that motion and I'll consider it as a contested matter. And at that point, I feel comfortable that, I can rule one way or the other, whatever I think is appropriate based on the parties' arguments. But I don't want to do it today without a motion unless it was by agreement. I just wanted to raise those issues for the parties to think about, mostly just in the name of efficiency, because it's not uncommon we get these discharge adversary proceedings after a state court judgment. And sometimes it makes sense to just let that get to conclusion in the state court first, but it's certainly, like I said, not a requirement. So as far as this morning, then, I'm just simply going to deny the motion to change venue. There's just not a basis for it in this context. Just discharge adversary proceedings are properly brought in the bankruptcy court, really the only court that has jurisdiction over those types of issues. And the only authority cited for changing venue was 28 U.S.C. 1412 and its companion Bankruptcy Rule 7087. And both of those really are limited to situations of transferring venue between federal district courts. It doesn't provide a basis for a bankruptcy court to transfer venue to a state court, particularly a state appellate court, and even more so when the substance of the litigation here is discharge, which is pretty much exclusively the province of the bankruptcy court. So I will just do a simple order that denies the change of venue. And like I said, after you discuss it, if you want to stay this, just submit an agreed order staying it. And if there's no agreement on that and you still think that's the best course of action, Ms. Lane, why don't you just file that motion? And until then, any party can file any motion consistent with the scheduling order in place until such time an order gets entered, if it ever does, staying the proceeding. But just some things to think about for today. I'll do a simple order denying the motion to change venue. Anything else for me, Ms. Lane, this morning?
Actually, I just have a procedural question for your scheduling orders. If we need to extend that and we don't come to an agreement to extend any due dates, then I'm assuming we're going to have to file a motion with the court.
Yeah, I mean, that's how you have to do it, but, be reasonable with each other. It's pretty uncommon that I have to rule on scheduling issues. And if it's helpful, I'm not interested in pushing things out a long way. I think people are entitled to get things resolved. But on the other hand, I understand that my scheduling orders are probably a lot tighter than people are used to who practice primarily in other courts. So if you can work out other dates, I'm certainly not going to push back against that. Just counsel should talk among themselves and then, either contact my chambers to make sure the dates are okay, or just send in a letter saying we've agreed on these dates. And when we get your letter, we will just issue an amended scheduling order, assuming, the parties are in agreement. But if you're not in agreement, then yes, unfortunately, you need to just file a motion.
All right. Thank you, Your Honor.
All right. Ms. Cox, anything further for you this morning?
Nope, that's it, Your Honor. Thank you.
All right,
I
thank you
appreciate
both
your
very
time.
much. Then you should see that order either later today or the first, maybe tomorrow. But in any event, it'll pop up on the docket pretty quickly. Thank you.
Thank you, Your Honor.
All right, thank you.
All right. Includes matters on the 10:30 calendar, so we will now be at recess again.
All rise.